Hey gang, Stephen Marshall, KYLandlordlaw.com. In my last update for you in late July, I told you that the CDC eviction moratorium was set to expire in a few days unless Congress renewed it. Well, it did expire for 3 whole days. And then on August 3rd, the CDC issued a new moratorium that they claimed was more targeted, more limited, even though it still applied to 90% of tenants. But yesterday, almost 1 year after the CDC initiated its moratorium on September the 4th of 2020, the United States Supreme Court, the highest court in the land, effectively struck it down. Here's how we got there. The case that led to yesterday's ruling by the Supreme Court started in a trial court in district court in Washington, D.C. And back in May, that trial court ruled that a group of landlords and realtor associations out of Alabama and Georgia had proven their case that the CDC did not have legal authority from Congress to issue its eviction moratorium. But the trial court also entered a stay of enforcement of its ruling until the matter could be appealed to a higher court. And what that means is that it refused to enter an order stopping enforcement of the moratorium. So the moratorium went on. The trial court's ruling got appealed to a federal appeals court. They agreed with the trial court, but they also refused to lift the stay. So the moratorium went on. And then in early July, the case made its way up to the Supreme Court. But the Supreme Court also refused to lift the stay. In a 5-4 decision, Justice Kavanaugh noted that although he did not believe that the CDC had legal authority for the moratorium, he was not going to lift the stay because it was set to expire just in a few weeks at that time on July the 31st. And at that time, the CDC had indicated that it would not extend the moratorium beyond the end of July. And so that led to my post there in late July about the expiration of the moratorium. However, on August 3rd, the CDC issued its new moratorium without any further acts or authorization from Congress. And so those landlords from Georgia and Alabama renewed their case back in the trial court, asking the trial court judge to lift her stay of her order so that her order stopping the moratorium would be enforced. At this point, the trial court judge refused, saying that her hands were tied because the federal appeals court and the Supreme Court had refused to lift the stay, and she felt bound by those precedents. The federal appeals court was the next stop, and they also refused to lift the stay on the same grounds. That set the stage for the case to go up to the Supreme Court for a ruling. And yesterday, the court issued an opinion that was basically a 6-3 vote that the CDC did not have legal authority to issue the moratorium, and that the stay of the trial court's order was lifted and could now be enforced to end the moratorium. So there we go. It's written in black and white. The ink is now dry. The CDC had no authority to do what it did, and the Washington, D.C. trial court's order ending the moratorium is now enforceable. You know, I've often thought to myself that I'd probably get on here and drink a pour of bourbon when I got to announce that the moratorium was over. But upon further reflection, I thought this isn't really a celebratory time with so many landlords waiting on thousands of dollars in rental payments. But this is a step towards getting back to normal, and for that, I am grateful. So with yesterday's ruling, where does that leave us? What's changed? 2 things. First of all, there's no legal reason that you cannot evict tenants for any reason, including failure to pay rent. You can give notices, you can file evictions, you can get judgments, and you can perform set-outs. So that's number 1. And then number 2, you no longer need to include any language in your notices to your tenants about potential protection from eviction. I had a post about how the Federal Trade Commission or the Consumer Protection Division had issued a regulation requiring certain language in your eviction notices. Well, that goes away with the end of the moratorium. You don't have to put any language in there notifying the tenants of potential protection from eviction, because there is no longer protection from eviction other than complying with your lease, paying your rent, etc. So those are the 2 things that have changed. 3 things that have not changed. we still have millions of dollars in rental assistance available. Kentucky still has around 24 million in assistance available. And earlier this week, the Treasury Department announced that they had amended their regulations to try to make the application process faster and easier. So let's hope that we actually see better results on that from the application process being faster. Let's hope that leads to faster payments for you. My prediction is now that the moratorium's gone, we're going to see that process speed up a bit to see the money get into your hands faster. So let's hope that plays out. Second, the Kentucky Supreme Court rule requiring a 2-week continuance in non-payment of rent evictions is still in place. That was not tied to the moratorium. That's a separate order that was issued by the Kentucky Supreme Court, and it is still effective. So, on your first court appearance in cases that only involve the failure to pay rent, the case must be continued for at least 2 weeks if the tenant if the tenant shows up to court. If the tenant doesn't appear, you can get your judgment. If it's a non-compliance case, you can get your judgment. If it's a non-renewal of lease case, you can get your judgment on the first appearance. But if it only involves failure to pay rent and the tenant shows up to court on the first appearance, the case must be continued for at least 2 weeks. And then the third thing, the amount of notice required has not changed. Whether you're CARES Act or not CARES Act, the end of the moratorium does not affect how much notice you have to give. So you can give those same notices to pay or vacate that you've been given. All right, so where does that leave us? Practically, it leaves you with a decision to make anytime that you have an eviction for failure to pay rent. You now have the option to get a judgment and remove the tenant from the property, even though it may take a couple of court appearances to do so. But with the rental assistance available, you can still choose to work with your tenant and allow them to stay in the property on the condition that they participate in the process to get the rental assistance to pay the debt. Those are your choices. That's your call, and it's one that you're going to need to think about for each court appearance for each tenant. Some tenants you may just need to get out of there. Some tenants may have shown a lot of good faith effort in trying to get the money for you. You may want to let them stay so you can get the money. That's your call, and it'll probably be different based on the circumstances of each tenant in each case. So today we have good news to report. Now, there's no guarantee that Congress will not on their own enact a moratorium on evictions, and that could change the Supreme Court's analysis a bit. They've indicated that it might. But we'll cross that bridge when we get there. I don't know that they've got the support to make that pass. There's lots that they need to be dealing with right now. So that's it for today. Please enjoy your weekend, and if that includes a nice pour of bourbon for you like it will for me, all the better. You can reach me, smarshall@trippleslaw.com if you need me. Otherwise, I think that's it for today. Take care.